Dear viewers, the fourth lesson is on types of conflict. So, we all know armed conflict are of two kinds. One is international armed conflict, another one is non-international armed conflict. So, we will be focusing on this particular lesson. The Geneva Conventions and their additional protocols use terminology of armed conflict instead of war. Basically, there exist two main reasons to introduce the concept of armed conflict and to prefer it above the notion or the name war. The first, the concept of armed conflict more aptly captures the spectrum of violent clashes between organized groups. Indeed, war frequently has the connotation of violence between states or between armed groups within a state of a very intensive form of hostilities in a collective way on a wide scale, or in other words, sustainable struggle by armed force of certain intensity between groups of a certain size consisting of individuals who are armed, who wear distinctive insignia, who are subjected to military discipline under responsible command. This definition of war, which has been used by national tribunals, is very restrictive and hence excludes other types of less intensive hostilities like border incidents and arms. Hence, in order to provide protection to victims of armed violence, the restrictive notion of war should be abandoned and replaced by a new concept, namely armed conflict, which also includes low intensity hostilities. A second reason for the introduction of the notion of armed conflict is more legal one. Common Article 2 of the Geneva Conventions 1949 provide for the application of the rules of the conventions in case of declared war or any other armed conflict which may arise between two or more of the contracting parties, even if the state of war is not recognized by one of them. Consequently, the concept of armed conflict allows for a better protection of victims regardless of formalism. After the notion of armed conflict was introduced, it was quickly adopted in other international humanitarian law documents and in the resolutions of United Nations General Assembly. A good description on armed conflict was offered by the International Criminal Tribunal of former Yugoslavia, which held that on the basis of the foregoing, we find that an armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups or between such groups within a state. International humanitarian law applies from the initiation of such armed conflicts and extends beyond the cessation of hostilities until general peaceful settlement is achieved. Until that moment, international humanitarian law continues to apply in the whole territory of the warring states, or in the case of internal conflicts, the whole territory under the control of a party, whether or not actual combat takes place there. This description neatly covers the wide range of hostilities contained in the notion of armed conflicts. Furthermore, it indicates the multi-dimensional aspect of the concept. Indeed, the ruling of the ICTY, that is International Criminal Tribunal for former Yugoslavia, makes a sharp distinction between the armed conflicts between states and armed conflicts in the ambit of a single state, whether between governmental forces and armed groups or between such groups, as long as the hostilities are characterized by protracted armed violence. Hence, in order to better describe the concept of armed conflict, it has to be embedded into two types of armed conflict existing. This will be done by firstly discussing the classical types of international and non-international armed conflicts, and subsequently addressing the more special cases. Now we will move on to international armed conflict. International armed conflict is the waging of hostilities between two or more states, or as common Article 2 of the Geneva Convention 1949 states, all cases of declared war or any other armed conflict which may arise between two or more contracting parties. Hence, whenever the armed forces of two states parties to the Geneva Conventions of 1949 are entangled in hostilities, the provision of the conventions and those of Additional Protocol 1 will apply. Although in modern times non-international armed conflicts are preponderant, international armed conflicts have not disappeared from the globe. A second problem relates to the intensity of the international armed conflict. In contrast with the situation of non-international armed conflicts, the severity and the duration of the international armed conflict is not relevant. In theory, a single border incident, the shooting down of a military airplane, or a small naval battle is sufficient to bring into action the Geneva Conventions and Additional Protocol 1. Consequently, every use of arms between two or more states brings the Geneva Conventions and Additional Protocol 1 into effect. Moreover, in the case of an international armed conflict, it is not even necessary that the conflict be armed. For example, the military occupation of a territory by another state without resistance by the other state, or when states declare war on each other without any armed combat or action. Now we will move on to non-international armed conflicts. Non-international armed conflicts are fought out between governmental armed forces and rebel factions or insurgents, or between various armed groups in one state without any international intervention by another state or United Nations. Non-international armed conflicts are the most common armed conflicts today and are often characterized by high mortality among the civilian population and cruel behavior by the warring factions. Moreover, these conflicts are not adequately dealt with in international humanitarian law. The Geneva Conventions of 1949 only devote one article, that is Common Article 3, to non-international armed conflicts, and Additional Protocol 2, which should elaborate the regime laid down in Common Article 3, suffers from limitation, a high threshold, and the absence of ratification by all states. Hence, Common Article 3 remains the basis of all non-international armed conflicts and is sometimes considered as mini convention within the Geneva Convention of 1949. Common Article 3 is vague since it offers no definition at all of a non-international armed conflict. It only applies to it. Hence, it will not always be an easy task to distinguish an non-international armed conflict from an international disturbances or an organized form of violent banditry. During the conference of 1949, several criteria were proposed to sharply delimitate the concept. However, none of them were retained. Moreover, states do often refuse acknowledging that an armed conflict is waged in their territory, since this position is often politically very problematic. Consequently, states have refused considering the ongoing conflict in their boundaries a non-international armed conflict and instead described the violence as mere internal disturbances, upheavals, riots and the like. Nevertheless, Common Article 3 was a revolution at its inception, since for the first time international humanitarian law was automatically applicable in a non-international armed conflict regardless of the recognition of belligerency by states, thereby lowering the conditions of severity and intensity which were previously required in case of civil war by international humanitarian law. Furthermore, Common Article 3 has evolved as one of the key provisions of the Geneva Conventions of 1949 and international humanitarian law in general. The International Court of Justice held that this provision is a minimum yardstick which also applies in international armed conflicts besides the more elaborate rules governing these conflicts, and is to be considered as part of the elemental consideration of mankind. Some authors even conclude that Common Article 3 is part of just cogence, that is, peremptory norms from which no derogation is permissible. Practice has developed criteria in order to delimit the scope of Common Article 3, not in the field of actors, occupied territory or ability to conduct sustained military operations, but criteria to differentiate between a non-international armed conflict and internal disturbances and riots. Indeed, as is evidenced by the exclusion of riots and similar violence in other humanitarian law documents, Common Article 3 is not applicable in very low armed hostilities. The violence has to pass a certain threshold. In the first place, the intensity of the hostilities has to lead to a deployment of military forces instead of police forces. The scope of application of Common Article 3 should be as wide as possible without, however, being applicable to de minimis these situations. Common Article 3 lays down very basic requirements, in particular the prescription of humane treatment without discrimination, the protection against torture and other cruel treatment, the prohibition of the taking of hostages and the right to a fair trial. These obligations can also be found in human rights treaties which do apply in peacetime and continue to apply during armed conflicts, although some human rights obligations can be suspended. On the other hand, a criterion to conclude for the application of Common Article 3 can exactly be found in the suspension of certain human rights. If an internal violent situation has so deteriorated as to suspend human rights obligations, one could argue that Common Article 3 should come operative, since it at least safeguards some basic human treatment. We will move on to Additional Protocol 2. New developments in warfare and opaqueness of Common Article 3 led to the conclusion that Geneva Conventions had to be updated and supplemented. Consequently, two conferences of government experts were organized in 1971 and 1972 by the International Red Cross Committee, which resulted in two additional protocols, one applicable in international armed conflict, other in non-international armed conflicts. Initially, it was the purpose of the later additional protocol to define and supplement Common Article 3. However, the conferences miserably failed in this regard due to stiff resistance of the developing countries. Hence, instead of defining all non-international armed conflicts, Only the most intense were defined and additionally regulated. As a result, Common Article 3 is applicable in all cases of non-international armed conflicts, including one which is regulated by Additional Protocol 2. First, Additional Protocol 2 is only activated in case of a non-international armed conflict waged between the governmental armed forces and an insurgent group or groups. It does not involve the conflicts between insurgent groups or various armed groups within a territory of a single state. The reason for this omission is quite awkward. According to the Conference of Government Experts, this situation was too theoretical to occur, while at the same time such conflict was waged in Lebanon. In any event, armed forces of the government is to be broadly understood. It does not only cover military forces but also paramilitary forces, which under national legislation do not fall under armed forces. Secondly, the insurgents have to be under a responsible command, which implies some degree of organization of the insurgent armed group or dissident armed groups. However, this does not necessarily entail that a hierarchical system of military organization similar to that of regular armed forces should be present. It merely means an organization capable, on the one hand, of planning and carrying out sustained and concerted military operations, and on the other, of imposing discipline in the name of a de facto authority. Third, the insurgents should exercise control over a certain amount of territory of the state as to enable them to carry out sustained and concerted military operations and to implement this protocol. Needless to say, these conditions are closely interrelated. If an insurgent group controls a part of the territory of a state, it is very likely to be well organized and capable of mounting military operations against the governmental armed forces, which in most cases are superior and better equipped. The amount of territory which should be occupied is not given and in fact is not relevant. The occupation of territory only has to be such as to allow sustained and concerted military operations and to apply the protocol, for example, the setting up of hospitals and prisoner camps. In any event, a minimum amount of stable occupation of part of territory is required. Hence, non-international armed conflicts consisting of guerrilla operations which result only in a temporary occupation of a small village or a town without absolute control over another part of the territory do not fall under Additional Protocol 2. Thus, Additional Protocol 2 requires military operations conceived and planned by organized armed groups. Lastly, the insurgents should be able to implement Additional Protocol 2. This is conceived as the fundamental criterion which justifies the other elements of the definition, namely being under responsible command and in control of a part of the territory concerned. The insurgents must be in a position to implement the Additional Protocol 2. The threshold for application, therefore, seems quite high. However, this threshold does have a degree of realism since the conditions laid down in this article correspond with actual circumstances in which the parties may reasonably be expected to apply the rules developed in Additional Protocol 2. Internationalized internal armed conflicts are armed conflicts waged in a state between government forces and rebel factions or between armed groups with the intervention of one or more third states supporting the government. The rebel factions are armed groups. This situation clearly shows the problematic nature of the dichotomy between non-international and international armed conflicts. Neither the Geneva Conventions nor the additional protocols suggest a solution for the problem which part of international humanitarian law is applicable to various situations. In examining internationalized internal armed conflicts, two main issues come to the foreground. First, which degree of third state involvement is needed? Indeed, not all interventions of third states into an internal conflict will transform the non-international armed conflict into an international armed conflict. Second, to what extent are the rules governing international armed conflicts applicable to all parties to the conflict? The level of involvement. Not every level of third state involvement in a non-international armed conflict internationalizes it. Indeed, while generally intervention by a state in another state without the latest consent is not allowed under international, this does only concerns the jus ad bellum and not jus in bello. Furthermore, there are various means of intervention, illegal or not, which do not necessarily transform the internal armed conflict into an international one. In a non-international armed conflict of a large scale, it is sometimes not clear which group is recognized as the legitimate government, and there is a possibility of recognizing different groups as legitimate government of one state by different states. Therefore, recognizing different groups as government of one state by different states lead to insurmountable problems and stalemate. Consequently, the non-international armed conflict becomes an international armed conflict between the intervening state and the opposing forces. Merely sending military experts and advisors to one of the parties in the non-international armed conflict by another state is not sufficient to make the non-international armed conflict into an international one, because those military experts and advisors do not act in the capacity of government officials of the intervening state. But if the foreign military experts and advisors are under exclusive authority of the sending state, then the conflict becomes an international armed conflict between foreign state and the group they are fighting against. In case if a state allow the departure of volunteers or mercenaries to a state in which the non-international armed conflict takes place, will not result in the internationalization of the conflicts. States are normally not responsible for the conduct of individuals which are not state organs. However, if a state is substantially involved in the armed actions of the volunteers or mercenaries, the picture changes, since this conduct can be labeled as acts of aggression against another state. While the acts of the volunteers or mercenaries as such may not be attributable to the state, it does not mean that due to its substantial involvement it is not a party to an armed conflict against another state. Hence, in this case, the non-international armed conflict becomes internationalized between the intervening state and the parties to the conflict against which the volunteers and the mercenaries are operating. Lastly, sending financial and material aid alone to the government or one of the rebel factions will never internationalize the armed conflict, even if the aid is substantial and has huge impact on the waging of the internal armed conflict. However, if a third state not only sends material and financial aid, but combines it with military and strategic support of operations of the armed group to the extent that in a general controls the armed group, then non-international armed conflict becomes internationalized. The International Court of Justice held in the famous Nicaragua case that the conduct of the rebel group is not attributable to the state intervening in the conflict unless it can be demonstrated that this state has effective control over the rebel group. Conversely, the International Criminal Tribunal for former Yugoslavia has decided that overall control over the armed group is sufficient to attribute the conduct to the intervening state in case of a well-organized paramilitary or military group, but retains the standard laid down by the International Court of Justice in the case of Nicaragua for individuals and unorganized sectors. Thus, in this lesson, we have studied the difference between the international armed conflict and non-international armed conflicts. Thank you.